Big breaking news right now. The Supreme Court has upheld a 10% reservation for the EWS in the general category. What we do know, and we saw the proceedings, they were transmitted live since it's the last day of the Chief Justice, UU Lalit. Now, Chief Justice of India, UU Lalit, and Justice Ravindra Bhatt dissented with the majority view on the economically weaker section quota. So 3 judges there ruling in favor and upholding the government's 10% EWS quota that they brought just before the 2019 elections. But the Chief Justice of India, Lalit, and Justice Ravindra Bhatt dissented with the majority view on that. So the Constitution bench, they're upholding the 10% reservation for EWS with a 3:2 majority. So a big victory there for the government. There had been as many as 40 petitions against the granting of this 10%, against this constitutional amendment, which gave 10% reservation for the economically weaker section from the general category. This is those who are not, who can't apply for any other quota of the OBC or SC and ST. So from the general category or the so-called upper caste, that they now have this 10% economically weaker section quota. So this means families that have an annual income of below 8 lakhs are now eligible for this quota, this 10% quota, and the Supreme Court there upholding this reservation in jobs as well as in educational institutions. So this is for families whose annual income is below 8 lakhs. Now they're eligible for 10% reservation in all colleges and government jobs. So 2 justices, that's the Chief Justice himself and Justice Bhatt, dissented from the majority view. And some of the big quotes we can bring you: reservation is an instrument for an affirmative action by the state. Reservation on economic criterion does not breach the basic structure of the Constitution. Exclusion of classes covered by Articles 15 and 16 does not violate Equality Code and does not damage the basic structure. Reservation for EWS does not violate the basic structure on account of the 50% ceiling limit. Well, let's go across to Himanshu now for more. And Himanshu, so interesting, initially we thought the Chief Justice was also in agreement with that majority decision, but it's emerged that this Chief Justice Lalit as well as Justice Bhatt, who did not agree with the other 3 in upholding this 10%.
दिया है उसमें एक सवाल अभी दूसरी बेंच के पास पेंडिंग है कि 8 लाख रुपए की जो सीमा ईडब्ल्यूएस पे बनाई है, वो 8 लाख रुपए की सीमा कहां से आई है, उसके पीछे क्या स्टडी है, उसके लिए इंतजार हो रहा था कि पहले संविधान पीठ ये तय कर दे, क्योंकि संविधान पीठ अगर ये तय कर देती कि यह संवैधानिक है तो तमाम मामला खत्म हो जाता। लेकिन ये बड़ी बात है यहाँ पर कि क्योंकि ये तो लागू करना पड़ेगा, एक पूरा संशोधन था संविधान में और सुप्रीम कोर्ट ने मान लिया है कि मूल ढांचे से छेड़छाड़ नहीं है, 50% का उल्लंघन नहीं है, अलग वर्ग है ये, इसको आप SC ST और OBC के साथ कंपेयर नहीं कर सकते हैं, उनके साथ कोई भेदभाव नहीं है। गरीब लोगों को उत्थान की जरूरत है, संविधान को लचीला होना चाहिए। केंद्र सरकार की तमाम दलीलों को इन 3 जजों ने माना है।
एक सवाल महत्वपूर्ण आशीष ये है कि आर्थिक तौर पर पीछे जो सामाजिक वर्ग है उनको आरक्षण की सुविधा मिलेगी। अगला महत्वपूर्ण सवाल ये होगा कि सुप्रीम कोर्ट ने क्या कोई मानक भी इस तय किया है, अपने जजमेंट में ये कहा है कि आर्थिक तौर पर कौन पिछड़ा है, नहीं है, इसकी पहचान कैसे हो, क्योंकि एक क्रीमी लेयर का प्रावधान तो SC ST OBC में है।
ये तमाम सवाल सुप्रीम कोर्ट ने संविधान पीठ में जब 7 दिन की सुनवाई चली थी, हिमांशी, तमाम सवाल उठे थे। पहला सवाल ये भी था कि आपने क्रीमी लेयर को, आपने कैप सीमा कैसे बनाई है, आर्थिक रूप से कमजोर कौन, अगर आपने आज उसको नौकरी दे दी और वो नौकरी में उसकी सैलरी 10 लाख रुपए हो गई तो वो आर्थिक रूप से कमजोर वर्ग कहाँ रहा, वो EWS रहा नहीं। तो उसके बाद क्या उसके बच्चों को या आगे उसके परिवार को क्या इस तरह का लाभ मिलेगा, ये तमाम सवाल थे। लेकिन सुप्रीम कोर्ट ने ऐसी कोई कैप नहीं लगाई है, वैध ठहराया है। तो जाहिर तौर पर जो केंद्र सरकार ने मानदंड बनाए थे, 8 लाख रुपए की जो सीमा तय की थी, लेकिन केंद्र सरकार ने बड़े दिलचस्प आंकड़े भी दिए थे और कहा था कि सिविल सर्विसेज में जितने लोग आते हैं उसमें EWS कैटेगरी में मैक्सिमम लोग जो है 2 से 2.5 लाख सालाने की सैलरी वाले होते हैं, यानी 8 लाख तो मैक्सिमम कैप है, 8 लाख तक के लोग हैं नहीं उस श्रेणी के। तो केंद्र सरकार ये बताना चाह रही थी कि इस देश में गरीबों की संख्या बहुत ज्यादा है और फिर ऐसे लोग जिनकी कमाई तो है लेकिन बहुत ज़्यादा नहीं है, वो सबसे ज़्यादा हैं। वो EWS कैटेगरी के हैं जिनकी सालाना आय 0 से लेकर 2 लाख या 2.5 लाख रुपए तक है। तो ऐसे में आप वो ये बताने की कोशिश कर रहे थे कि EWS कैटेगरी में मैक्सिमम वो लोग हैं जिनकी सालाना आय 2.5 लाख रुपए से ज़्यादा नहीं है। तो ऐसे में केंद्र सरकार का दायित्व बनता है कि एक समाज का ऐसा तबका जिसको किसी तरह का कोई संरक्षण नहीं है, किसी तरह का कोई आरक्षण नहीं है, वो सिर्फ इस वजह से कि वो सामान्य वर्ग के हैं, क्या उनको ऊपर उठने का मौका नहीं मिलना चाहिए? क्या उनको अपने उत्थान का मौका नहीं मिलना चाहिए? क्या सरकार को उनके लिए कुछ नहीं करना चाहिए? क्या संविधान ये कहता है कि गरीब लोगों के उत्थान के लिए कुछ मत करिए? क्या संविधान को लचीला नहीं होना चाहिए? ये तमाम सवाल यहाँ केंद्र सरकार ने रखे थे और सबसे बड़ी बात ये कही थी कि हम जो मौजूदा जो इंफ्रास्ट्रक्चर है, आरक्षण है, उसको अधिकारों में कोई कटौती नहीं कर रहे हैं। एजी ने बहुत बड़ी बात कही थी कि SC, ST और OBC वो लाभों से, आरक्षण के लाभों से लदे हुए हैं पहले से ही, उनको इतने लाभ दिए गए हैं कि अब वो इसमें भी आरक्षण नहीं मांग सकते हैं।
लेकिन इसी फैसले को जस्टिस रविंद्र भट्ट ने चुनौती भी दी है और ये कहा है कि ये फैसला गलत है कि जो आर्थिक तौर पर पिछड़े हैं SC, ST और OBC कम्युनिटी में। जी
All right, so there Himanshu talking about the big breaking news right now that the 10% EWS quota has been upheld by the Constitution bench of the Supreme Court, and so Supreme Court they're backing in a 3:2 judgment, 10% quota in colleges and government jobs for the economically weaker sections, that and saying that it's not discriminatory and does not alter the basic structure of the Constitution. The judges said the EWS quota does not violate the Constitution on account of the 50% ceiling limit. Let's go across to Arvind now for more. And Arvind, so a big win for the government today. The Supreme Court upholding the 10% quota to the EWS, and also, however, it was a 3:2 judgment with the Chief Justice, one of the dissenting judges.
Yeah, Gargi. Supreme Court Constitution bench led by Chief Justice of India, UU Lalit, has upheld the 103rd constitutional amendment wherein the central government led by BJP introduced this 10% reservation for the economically weaker section. So almost 39 petitions are filed in Supreme Court challenging the constitutional validity of this very reservation given to the economically weaker section on two very important grounds. One, they said that a reservation cannot be given solely based on an economic criteria. That was the first ground. And second ground, they said that this particular reservation of 10% to the economically weaker section, it breaches the 50% ceiling or the cap that was held, that was capped by the Supreme Court Constitution bench in 1992 in the Indira Sahni case. And they also said that if at all if any change is made to this particular 50% ceiling, then that goes against the very basic structure of the Constitution, and the basic structure of the Constitution cannot be amended by the central government as held by the Supreme Court in the Kesavan Bharati case. So these three were the important arguments that were put forth by the petitioner's side. So after hearing both the side argument, today Supreme Court gave its verdict in a majority, in a 3:2 majority. 3 judges of the 5-judge bench have held that the 103rd constitutional amendment does not violate the basic structure of the Constitution. That's the conclusion, and with the 3:2 majority, this 10% reservation for the economically weaker section has been upheld by the Supreme Court. Just 2 judges, Chief Justice of India, UU Lalit, and also Justice Ravindra Bhatt, both of them differed with the majority view, saying that any exclusion, because according to the petitioners, the backward classes, they are excluded from this particular 10% reservation scheme, and that's why they said that this particular exclusion does not go well with the Constitution, because Constitution does not allow any kind of exclusion when it comes to such affirmative action. And agreeing with that contention, both Chief Justice of India, UU Lalit, and also Justice Ravindra Bhatt have said that this particular 103rd Constitution amendment is unconstitutional. But because 3 judges have held it constitutional with a majority of 3:2, the Supreme Court Constitution bench has upheld the 103rd Constitution amendment. That means that the 10% reservation for the economically weaker section has been upheld by the Supreme Court.
All right, and what if you could give us more details of what the dissent was that Justice Bhatt, what did he have to say?
Gargi, Justice Ravindra Bhatt's dissent is mainly on the ground, saying that this exclusion, because according to the petitioners, backward classes are not included in this economically weaker section. It has been provided only for those people from the general category with this layer of the cap of 8 lakh income per annum. That has been a criteria to get oneself included in this 10% reservation, and that's where Justice Ravindra Bhatt has said that any exclusion cannot be held valid as per the Constitution, and that's why that has been the ground on which Justice Ravindra Bhatt has said that Section 2 and Section 3 of the 103rd Amendment is held unconstitutional. Though Chief Justice of India, UU Lalit, has not written a separate judgment, has not authored a judgment in this particular case, but he has concurred with the dissent opinion of Justice Ravindra Bhatt. So out of 5 judges, 4 judges wrote their own separate judgment. First 3 judges, Justice Dinesh Maheshwari, Justice Bella Trivedi, Justice Padiwala, they concurred with the opinion that this particular 103rd constitutional amendment is constitutional because it is an affirmative action taken by the government in order to promote social equality, and that's why they said that this does not violate the basic structure of Constitution. But on the ground that because it excludes one category of people, that's why Supreme Court Judge Justice Ravindra Bhatt held that this is not constitutional, and Chief Justice of India, UU Lalit, also concurred with this dissenting opinion.
Right, and Arvind, this is bound to get a huge reaction because at the time that this was announced, many were unhappy with this. Political parties, however, did not speak out much on this, did not, want to come out as being critical of this 10% quota. But there are many sections that had spoken out, which is why you had as many as 40 petitions against this 10% quota.
Yeah, Gargi, that seems to be this one. Almost 39-40 petitions were filed in Supreme Court challenging this 10% reservation for the economically weaker section. They condemn the same thing, saying that the economic criteria alone cannot be the basis of giving reservation, because the Constitution clearly says that the reservation should be promoted for socially and economically backward classes. But in this particular case, because the central government has taken this 8 lakh per annum as this criteria for getting oneself included in this 10% reservation for the economically weaker section, they said that economic criteria alone has been made as a criteria for this. Economic status alone has been made the criteria for this reservation, and that's why they challenge this. And 39 petitioners have challenged it. What is very important is that we are still waiting for the detailed copy of this particular judgment, because one also has to keep in mind that several states already have more than 50% reservation in several states. From Tamil Nadu already has 69% reservation, and several states, Maharashtra to Karnataka to Haryana, all these states have more than 50% reservation. That's something that have been challenged, and several such petitions are already pending in Supreme Court. If the Supreme Court is allowing this 10% reservation for the economically weaker section above the 50% existing reservation, that means that this particular bench of the Supreme Court in a majority view has held that the breaching of 50% is flexible. That 50% ceiling limit that was kept, that was confirmed by intrastani judgment, that has been considered by these 5 judges, and they have also allowed this 10% in extra to the 50% already available. If that is allowed, if that is upheld, then that will also have this cascading effect on all other states that already have more than 50% reservation, and those matters are also pending before several judges before the Supreme Court. So we are still awaiting for the detailed judgment of this in this particular case, but it's clear in a 3:2 majority, Supreme Court has upheld that the 10% reservation for the economically weaker section.
All right. Thanks so much, Arvind, for joining us. With that, let's go across to Sunil Prabhu now for more. And Sunil, what are the reactions coming in to this big judgment? The Supreme Court, they're upholding that 10% quota for EWS.
Well, I think the most important aspect, Gargi, if you heard Justice Dinesh Maheshwari give his majority judgment, which was concurred by his fellow judges, they pointed out, while agreeing with him about the fact that there has to be a timeline for reservation. It's a 3-2 verdict. Justice Lalit as well as Justice Ravindra Bhatt not agreeing with this entire line of thinking that Justice Maheshwari and the majority viewed. I think that aspect needs to be looked in, and definitely something that political parties who have always used reservation as a means of getting electoral gains. As you rightly pointed out, in the backdrop of the BJP doing miserably in the assembly elections, it was decided to bring in this EWS in 2019 as a spin-off ahead of the elections of 2019. And it's in that context now that the Supreme Court has upheld it, will now become the law of the land. But as has been pointed out, it will definitely have repercussions, because this will definitely mean that not only scheduled castes as well as scheduled tribes, OBCs and socially economically backward castes, there will be another new pie of economically weaker sections, which basically means even people from the upper sections of society will be eligible for reservation. So we'll have to see how this plays out. This will definitely have its a huge impact, but this was, as we pointed out, done purely for electoral purposes ahead of the 2019 Lok Sabha elections. And now two brother judges making it a point, while concurring with Justice Maheshwari, to say not once but both of them saying that there has to be a timeline for reservation, because this was envisaged, initially for 10 years. It has continued. We are on the 75th year, and hoping that there will be a casteless egalitarian society soon in this country.
All right, that was an observation the judges had when reading out, the decision. But yes, Sunil, so we'll get more reactions to this big breaking news that we've been bringing you. The Supreme Court backing the 10% quota in colleges and government jobs for the poor or economically weaker sections. This was something that was, this constitution amendment was brought in by the BJP government just ahead of 2019 elections. Today, the Supreme Court says it is not discriminatory and does not alter the basic structure of the constitution.
Chief Justice of India, UU Lalit, and Justice Ravindra Bhatt dissent with the majority view on the economically weaker section quota. The Supreme Court Constitution Bench upholds a 10% reservation for the economically weaker section with a 3:2 majority. The Supreme Court today delivered its verdict on the validity of the central law for the 10% reservation benefits to the economically weaker section, the EWS. The bench ruled on a bunch of legal issues surrounding the validity of the 103rd constitutional amendment providing for the 10% reservation for the economically weaker section. By the 103rd Amendment Act, in the Constitution provided 10% reservation in jobs as well as in education to the EWS, who were to be people other than the scheduled caste, scheduled tribe and the OBC, and whose annual family income was below 8 lakh rupees. This was introduced just before the 2019 general elections. As many as 40 petitions were heard by the Supreme Court against it, including by the state of Tamil Nadu. So we have my colleague Arvind joining us. Arvind, first take us through the proceedings in court. What was said and on what grounds has this been upheld?
Supreme Court Constitution Bench, in a majority view of 3:2, today has upheld the validity of this 103rd constitutional amendment, through which the central government had introduced the 10% reservation for the economically weaker section. So, three judges, Justice Dinesh Maheshwari, Justice Bella Dwivedi, and also Justice Pardiwala have held that this particular 10% reservation for the economically weaker section is not discriminatory in nature, and they have also upheld that this particular 103rd amendment, constitutional amendment, is not violative of the basic structure of the constitution, whereas Chief Justice of India, UU Lalit, and also Justice Ravindra Bhatt, both of them have held that this particular exclusion in this 103rd amendment, that's the other backward classes not being included in this 10% reservation for the economically weaker section, is actually discriminatory and it does not go well with the constitution, and that's why they have said that Section 2 and Section 3 of the 103rd constitutional amendment is unconstitutional. So we have Advocate Chadhan Farsad with us. He is one among the petitioners. He appeared for one among the petitioners in this particular case. So Farsad, today Supreme Court, in a majority view of 3:2, has upheld the 10% reservation for the economically weaker section. So what is the main ground on which the majority view, they concluded that 103rd amendment, constitutional amendment, is not unconstitutional?
So there were two main grounds of challenge to this amendment. One was that economic criteria cannot be the sole basis of grant of reservation. On that, all the 5 judges have agreed that it can be the sole basis of grant of reservation. So on that, there is unanimity. There was a second ground of challenge, which is that the exclusion of backward caste and namely SC, STs and OBCs is violative of the basic structure inter alia, because they are the poorest amongst all the groups. So if you're using economics as a criteria or poverty as a criteria, then be consistent in that. Don't bring in caste into that. Now on that ground, 2 of the judges have disagreed and said for that reason the amendment is violative of the basic structure, and therefore have struck down the entire amendment because that exclusion is unconstitutional according to them. So there are 2 diametric points of view only on one point, but that point is of huge consequence, which is the exclusion of backward caste from this economic criteria, because effectively what it becomes otherwise is a forward caste quota for economically weak within the forward caste, and that is something which is constitutionally not acceptable.
So also because there is this Indira Sani judgment that have kept the ceiling 50% for the reservation. Has that been dwelled into by this constitution bench, because this particular 10% reservation for the EWS is above the 50% quota, right?
Yeah, so the majority in the same majority has also held that the 10% beyond 50% is permissible. So they have in effect said that the 50% limit is not a rule of basic structure, and therefore it's exceeding that limit through a constitutional amendment will not violate the basic structure. Now that of course opens the Pandora's box. I don't know how they have couched it. We'll have to read the opinions carefully. But if they have not put some safeguards or guardrails there, then it opens the Pandora's box into different kinds of reservations which in the future can be introduced way beyond even 60%.
Yeah, because there are several states where more than 50% reservation are still existing, and there are several such petitions pending before the Supreme Court also. So with the Supreme Court in a way considered the Indira Sani judgment and said that the above 50% is well within the limit, if at all, well within the reasonable permission, if at all, if the government could come up with some kind of a data to justify such an extension in the increase in the reservation?
See, I don't think they would have gone by, at least at this, I have to read the opinion, but at least at the stage of arguments, the 10% was not sought to be justified so much on data. So I don't think they have gone so much on data. They have gone by the judgment of Parliament on through a constitutional amendment process. So that's what they possibly would have gone by. But we don't know right now. We'll have to examine the opinion, and then what is repercussions. If, as I said, if there are no guardrails which have been imposed, then it opens a Pandora's box.
Okay, that's Shadan, who appeared for one of the petitioners in this particular case. Like he mentioned, on this very particular point, whether economic criteria alone can be the sole criteria for this 10% reservation, for which, according to him, all the 5 judges have agreed with that contention, that economic criteria can alone be a basis for giving the reservation. That all the 5 judges have agreed with. But on this very limited point, whether the backward classes, people from backward classes can be excluded from this 10% economically weaker section reservation, that's something that 2 of the judges, Chief Justice U.U. Lalit and also Justice Ravindra Bhatt, have dissented with all other 3 people, saying that this is discriminatory in nature. The other backward classes people should also be, if they are not included in this 10% reservation, then according to them that unconstitutional. But whereas the other 3 judges have held that that particular exclusion can also be allowed, though that does not breach the basic structure of Constitution.
Right. Arvind, first take us through those key issues, those 3 key issues that were discussed in court today, and also, the petitions that were filed, 40 of them that were heard.
Yeah, Divya, almost 39 petitions were filed. Some of the petitioners had moved the High Court, and Supreme Court, by its own motion based on the request from the centre government, transferred all those cases that are pending before the several High Courts to itself, because Supreme Court was seized of the matter, because centre said that this is an act that was passed in Parliament, and that's why they wanted the Supreme Court to adjudicate this matter instead of various High Courts, and that's why the petitions that were pending in several High Courts were transferred to the Supreme Court, and almost 39 petitions were heard by the Supreme Court Constitution bench. So if you could see the important issues, one, like we have been explaining, the very basis, can economic criteria alone be the sole basis for granting reservation? That's something that was the first question that was raised by the petitioner. They have said that the reservation can be given based on for socially and economically backward classes. If that's the case, can economic status of a person alone be the criteria for giving reservation? That's something that was the first question that was raised before the Constitution bench. And second one, exclusion of the backward classes in this particular 10% reservation, because in this 10% economically reservation for the economically weaker section, only those people from the general category who have the annual income of less than 8 lakh, they were eligible for this. They are eligible for this 10% reservation under the economically weaker section, and that's why the petitioners also challenged it, saying that because it is excluding the backward classes from this 10% reservation, and that's why they called it a discriminatory in nature. And third one is the Indira Sahni judgment that said that the maximum cap limit or the maximum ceiling limit of the reservation is only 50%. So on these three grounds, several petitions were filed, and three judges have held that the 10% reservation through the 103rd constitutional amendment does not violate the basic structure of the constitution. It is not discriminatory in nature, and they have also upheld that the 50% ceiling is flexible. It's not mandate. It's not the fixed limit. That's flexible, and that's why 3 of the 5 judges have upheld that the 103rd constitutional amendment is valid, is constitutional. But whereas on the sole ground that because it is excluding the other backward classes from this 10% reservation, that's where 2 of the judges, Chief Justice of India U. Lalit and Justice Ravindra Bhatt, dissented with the majority view.
Right. Thank you so much, Arvind, for getting us all those details. And to get a broader perspective, we also have Tehseen Poonawala, who is a petitioner in the EWS quota. And we also have Ashwini Dubey, the advocate of Supreme Court, joining us this afternoon. Let me take my first question to Ashwini Dubey. On what grounds has this judgment been upheld?
See, first of the foremost question which arose from 1992 judgment, Indira Sahni judgment, which fixed the cap of 50%. But one of the tests, let me tell you for your viewers' point of view, that one of the tests which was decided in Indira Sahni judgment was that the reservation granted under Article 16(4) should not cross 50%, but only in exceptional circumstances this strict rule can be transgressed, but when an extraordinary or a special case is made out, and only with the application of extreme caution. So in fact, if we discuss this Indira Sahni judgment and we see all of the tests, there was no complete embargo for increasing it, but only thing is there has to be a basis to it. Now, the second question is there are 2 constitutional provisions, because the sole basis for 103rd amendment was on 2 legs. One is there is principle of equality, which prohibits the state from discrimination against any citizen on the ground of religion, race, caste, sex, place of birth. And Article 15 what guarantees equal of opportunity for all citizens in matters relating to employment or appointment to any office under the state. And the second is the special provisions, because under Article 15(4), which empowers the state to make any provision for the advancement of any socially and educationally backward classes. I'm again using the word classes, not the castes. Caste. It is the class, backward classes of any citizens, which is in the opinion of the state is not adequately represented in the service under the state. So the constitution does not say caste, it says the class. So class includes the economically weaker section, because there is if we see the Indira Sahni judgments, one of the tests was that the state will ensure that the survey is done, and those castes which have already uplifted and which have socially and economically have joined the mainstream, they should be excluded from the benefit of the reservation, and also their OBC status should go and they should be treated as general. But in order to appease the political voters, in order to appease the politics, and then politics, the Dalit ko Mahadalit banaya, OBC reservation was increased from...
Poonawala also with us. Tehseen, exceeding that 50% limit breaches a cap that was set in 1992. So how is this not violating the 50% cap that was set by the Supreme Court itself?
Divya, good afternoon. Thank you so much for having me in the show. Good afternoon to all your viewers, and good afternoon to Ashwini Bhai. I was one of the petitioners who opposed the 103rd constitutional amendment and the EWS reservations, and I still disagree with the Honorable Supreme Court, though I bow before the apex court. I haven't read the judgment in full because I believe this will open a Pandora's box. But from what I can tell you and what our arguments were, let me just get into issues that Ashwini Bhai led. Ashwini Bhai says, look, here's the there is discrimination on the basis of religion and caste. Actually, affirmative action is the need of the hour. Now, let me just put out data before you. How many of our fellow citizens who are Dalits and OBCs, as of today, judges in the Honorable Supreme Court? With due respect and with folded hands before the Honorable Supreme Court, how many Dalit or OBC judges were a part of this particular judgment? How many Dalits or OBCs have been Chief Justices of the Honorable Supreme Court, or are today Chief Justices of courts across the country? In the state of Uttar Pradesh, how many Dalits or OBCs are SPs or DMs or police commissioners? When we talk about, look, it's 75 years post-independence, how many vice chancellors today are Dalits or OBCs? This is they haven't got the full benefit of affirmative action even today. I completely agree with Ashwini Bhai, with every single viewer or every single person who says that economic criteria must be the basis for health. Therefore, your Ujjwala scheme, your Ayushman Bharat, your 80% Indians who get food, that's not discriminatory. If you're poor, whatever religion, caste or sexual orientation you belong, you'll get food, you'll get Ayushman Bharat health, you'll get insurance, you'll get Manrega. But you cannot get reservation based on economics. That must only be based on caste. Health, financial health must be based on economic criteria, no doubt about it. But reservation must be based on caste. And when you say that caste is now irrelevant, please answer my question. How many today police commissioners are Dalits in Uttar Pradesh? How many judges of the Supreme Court are Dalits today or OBC? Jiski jitni abadi, uski utni hissedari. Let's put out the OBC quota in the 2011 census and see how many of them have got the perks of affirmative action. Let's put out the data and talk on data. That doesn't happen.
Right. Would you like to react to that, Ashwini Dubey?
Yeah, thank you. See, EWS reservation in any way does not encourage upon or violate the fundamental rights of the citizens, which my brother Tehseen Poonawalla is representing. The EWS reservation does not violate the equality code or violate the essential feature of constitution and does not breach the 50%, which has been fixed in Indira Sahni judgment. As rightly said from time again, that even the reservation benefit has not been extended to those marginalized people who really need it, but that has been given to those who falls within creamy layer, who has their income for more than 8 lakhs rupees per annum, which is the cap fixed by the Supreme Court. Second aspect, in the constitution framers have introduced this reservation per se, the constitutional reservation to SC and SC only, not the OBC to whom my brother Tehseen Poonawalla represents. SC and OBC, SC and ST for a period of 10 years only. As rightly said by Justice, there was a lot of debate in the constitution when the constitution was being framed. One of the debate was कि बैशाखी बना के इनको आगे बढ़ाना चाहते हैं या you want to socially uplift them. This OBC reservation came into existence in 1992.
Right, Tehseen, come in. You would like to react to that?
As somebody who's doing his PhD on the Indian Constitution and the evolution of the Indian Constitution, let me just tell my dear friend and my very learned friend, yes, there was a very strong argument on the Constitutional Assembly on framing of the reservation policy for SC/ST fellow citizens. But yes, it was for 10 years. But that is quoting Baba Saheb Ambedkar selectively. I am asking you, and just answer one question today in 2022. How many Dalit Chief Justices have been there of the Honorable Supreme Court? Just answer that question and I'll stop my argument. I am asking you today in 2022, how many Dalit and OBC and ST police commissioners are there in Uttar Pradesh or district magistrates are there? Just put it out. I am asking you one question. In 2022, how many chief justices are today Dalit or OBC in all the high courts in India? And I'll stop my argument there. वो नहीं है ना sir. जिसकी जितनी आबादी उसकी इतनी हिस्सेदारी दे दो. कितने vice chancellors, how many vice chancellors today in 2022 on this particular day are Dalits and OBCs in the national universities? It's much lesser than the percentage that they represent in our country. Why? And I am asking you with humility, bowing before the apex court, I bow before the majesty of the apex court. How many of these 5 judges for whom I have a lot of respect for Dalit or OBC or ST who gave this judgment? See, they haven't got the fruits of reservation. I am not disagreeing with my learned friend. Yes, if you are economically poor, they must get treatment in hospital. If you are economically poor, you must get the Ujjwala Yojana. If you are economically poor, you must get food. That is not what we are talking about. We are mixing two issues. If your reservation is based on caste, economic must go to anybody who is poor, irrespective of not just caste or religion, even gender. If you are gender minority, you must get economic reservations. I'm not disputing that. We're talking about caste-based reservations. How did EWS category come in here? Just answer my friend, how many chief justices of the Honorable Supreme Court are Dalits? And I'll end my argument here, I'll concede to you. Wo answer kar dijiye, sir.
Ashwini Dubey, our constitution doesn't allow economic grounds for reservation. Then how come we've seen this amendment by the Supreme Court?
That is what. When the Indira Sahni argument was being heard and judgment was delivered, there were 3 more judges. Honorable Justice Dr. T.K. Thoman, Justice Kuldeep Singh and Justice R.M. Sahai. What was the opinion of the minority? That all types of reservation came under the purview of 16.4 and no reservation were permissible under Article 16.1. And they also say that the class cannot be changed with the caste. And that I said in my opening argument that one of the parameter, one of the tests that in exceptionally circumstances, the center can transgress the 50% cap, the cap which has been fixed. And now the economic criteria, basic object says class, economically weaker section class, does not say class. As my brother is asking the hypothetical question, I cannot answer that. I cannot be so blunt as my brother is. I cannot put on the any question on the authority or the constitutional privilege given to the judges or the judges who are able judges. Out of 5, 3 judges ruled in favor of 103rd Amendment and 2 only deferred. There were dissenting view. I do not want to question. I do not want to say it's his personal view. But the point herein is, when the court has held that Article 16.1 and 4 are the facets of the same equality principle, the amendment bestowing double benefits, it is not correct. It is incorrect. No double benefit. Only the marginalized from the upper category are getting, whose income is not more than 8 lakhs rupees. And that is why they should have, as per the constitution, you cannot discriminate कि मैं ब्राह्मण परिवार में पैदा हुआ और मैं गरीब हूँ, तो I cannot get the benefit. And my brother's clients have born in an elite class और OBC है, तो they should get the reservation. इसीलिए जरूरत है, equality before the law is the basic fundamental question.
Tehseen, come in please. Yes.
Quickly, I completely agree with my learned friend. If you're economically weaker, let's say from a Brahmin family, hypothetically as he puts it, you must get admission in a hospital and free treatment under Ayushman Bharat. If you're economically poor, hypothetically, like from a Brahmin family, as my friend Ashwini Bhai puts it, my learned friend, of course you must get the food that 80% of India is getting. Who's disputing it? That is not the argument. My argument is based on reservation, not on economic. Economic, if you're poor, you must get it. Not just caste or religion, even sexually minority genders or gender minorities must get it. That's not what we are opposing. What we are talking about is reservation based on caste. Now let's note the question.
Right, I'm afraid we're completely out of time. Thank you so much, Tehseen Punewala and Ashwini Dubey, for joining us this afternoon on NDTV. To get you more details as to what happened in court today, let's just listen in to Justice Lalit.
I have concurred with the view taken by Honorable Justice Lalit in its entirety. So effectively, the decision speaks to prove.
In this background, reservation structured singularly on economic criteria does not violate any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India.
I have concurred with the opinion of Brother Justice Maheshwari. However, I have went down certain my views also. As well settled, it must be presumed that the legislature understands and appreciates the needs of its own people. Its laws are directed to the problems made manifest by experience, and its discriminations are based on adequate norms. Therefore, the constitutional amendment could not be struck down as discriminatory if the state of facts are reasonably conceived to justify it.
जिस तरीके से आज जो जजमेंट आया है, जो 103 अमेंडमेंट था, उसको चैलेंज किया गया था, क्योंकि 103 अमेंडमेंट में ये एक्सक्लूड कर दिया था ओबीसी एससी एसटी को, तो ये वायलेट कर रहा था आर्टिकल 14 को, राइट टू इक्वलिटी को। इस इशू को लेके याचिका फाइल हुई थी कि आप आर्थिक आधार पर आरक्षण दीजिए, मगर जिस तरीके से एक्सक्लूजन हुआ है ये गलत हुआ है, जिसको माइनॉरिटी जो व्यू आया है चीफ जस्टिस और जस्टिस रविंद्र भट्ट का, उन्होंने इस चीज़ को माना है।
अब आप लोग इस फैसले को कैसे देखते हैं?
ये फैसला एक नए युग की शुरुआत कह सकते हैं कि जिस तरीके से ये 91 में इस तरीके का रिजर्वेशन दिया गया था, मगर 91 में जब ये इंदिरा साहनी का जजमेंट आया तो ये माना 9 जजेस ने कि जिस तरीके से आर्थिक आधार अगर आप रिजर्वेशन का लेते हैं तो ये कॉन्स्टिट्यूशनल फ्रॉड है। उस इशू को उसके बाद में कभी फिर इसके बाद गुजरात में एक बार जरूर दिया गया था 10% रिजर्वेशन थ्रू नोटिफिकेशन, मगर वो भी हाई कोर्ट ने स्टक डाउन कर दिया था। उसके बाद में एसएलपी यहाँ पेंडिंग थी। इलेक्शन के पहले आनंद फानंद में 10% आर्थिक आधार पर आरक्षण दिया गया, जिसको आज यहाँ पे मेजॉरिटी व्यू है जस्टिस महेश्वरी के साथ में जस्टिस बेला त्रिवेदी एंड जस्टिस पारदीवाला, इनके व्यू ने अपहेल्ड किया है कॉन्स्टिट्यूशन अमेंडमेंट को।
क्या कोई रिव्यू वगैरह का भी
हमारे क्लाइंट का अभी कहना है, अब लीगल एडवाइस लेंगे। बाकी जो हमारा जो व्यू था, जिस बेसिस पे हम लोगों ने पिटीशन फाइल की थी, वो माइनॉरिटी जजमेंट में बिल्कुल झलक रहा है और इसमें अच्छी संभावना बनती है कि इसमें रिव्यू फाइल की जाए।